Hello friends, how are you? Myself is Dr. Jinesh Soni. I am a corporate lawyer. In a long career of corporate litigation, I intrally observed the proceeding of multiple check bounce cases. And even today I am going to share my experience concerning one of the most important cases, and I will also rely on judgment of Honorable High Court wherein the accused had been acquitted from a false check bounce case. Do you want to update your information or knowledge on the subject? For this, I request all of you to have a notebook with you with pen or pencil so that whatever I am going to narrate you could be maintained by you in recorded format to enhance your knowledge or information, so that if you are having a trouble, you could easily contest the issue without getting panic or worry. Please note down the name of judgment, and later on we will discuss the points of defense strategy so that we could ensure our winning in a false check bounce case. Judgment name is Uma Shankar versus Anil Sood. Judgment is pronounced by Honorable High Court. It is pronounced on 8th of July 2025. In that case, the concerned accused was convicted by the concerned trial court and by the Sessions Court under Section 138 of NI Act. And finally, he submitted a revision before Honorable High Court. But as we know that in a revision jurisdiction, the scope is limited. Honorable High Court is not allowed to scrutinize entire evidence, unlike the appellate court. The court has to see the legal error. If there is a legal error, then the court could intervene, otherwise not. So we have to keep in our mind that principle also. In that case, a story had been set up by the concerned complainant. He submitted that he is known to concerned accused, and that's why he has given certain amount of loan to accused, that is rupees 60,000. To pay the amount, the concerned accused given a check with a promise or assurance that the payment will be received to the concerned complainant on being presentation of check. When the check was presented, it got dishonored due to reason account closed. Finally, a legal notice was given and complaint was filed. When the accused appeared, he set up multiple points in support of his defense, but all of them was not considered by the trial court as well as by the Sessions Court, and ultimately the concerned division petition had been filed to incline remedy. He submitted that the actual amount is rupees 40,000, not 60,000. He submitted that the check is a security check, means a blank signed check. But all these points could not be taken into consideration by the concerned High Court, as we know that the concerned accused has to show the legal error. If he is not in a position to show the legal error, in that scenario he could not be succeeded, and that's why the concerned defense counsel inter alia submitted the argument to show that in the present case at hand there is certain non-legal compliances which are totally beneficial to the accused, and inter alia the case of complainant deserves to be dismissed. He submitted that the prime document to show a valid check dishonor is the memorandum of bank. But in the present case at hand, the concerned memorandum is not signed and sealed, and apart from that, it is basically a printout. So, if it is a printout, in that scenario, the concerned complainant is bound to follow the process of Section 65B of Indian Evidence Act. And apart from that, there is no compliance of Section 65B of Indian Evidence Act. In that scenario, the document cannot be said to be admissible into evidence. He submitted that the entire amount has been repaid, and to support the same, a diary had been submitted. He submitted that in the concerned diary, the entries are denied but signature are admitted by the concerned complainant. And when the concerned complainant inter alia admits its signature, he is bound by the content of the consent document. He submitted that there is no specification of the alleged loan when it is given, and apart from that, regarding the source authentication, there is no document on the record. Inter alia submitted that when the amount is repaid and the evidences are submitted, in that scenario, case is duly covered by the citation of Honorable Supreme Court titled as Dashrath Bhai versus Hitesh. Citation is 2023 Volume 1 SCC page 578. In that case, it is submitted that check can be presented for due amount. But if the concerned complainant received the amount, in that scenario, he is duly bound to introduce the same on the record. In case he failed to do so, in that scenario, the cause of action goes away and concerned accused could use the said scenario as a point of defense. And ultimately, looking at the facts and circumstances and legal non-compliances, Honorable Court inter alia acquitted the accused and finally dismissed the complaint of the concerned complainant. The present judgment inter alia enlighten us four important principles of law. Number one, the memorandum issued by a bank should be signed and sealed by the official. If it is not, it is fatal for the prosecution. Number two, if the amount is paid before the check bounce, in that scenario, the concerned complainant is bound to enforce the same accordingly to find out the real due amount. If you fail to do so in that scenario, it is beneficial for the accused. Apart from that, the concerned accused could sustain the alleged transaction by showing the account's entry, or if it is in cash, he may submit the defense witnesses to corroborate the said transaction on acquittal basis. Apart from that, if he is having a diary in which there is signature of concerned complainant, even though the concerned complainant inter alia rejects or denies the concerned transaction, but by the virtue of signature so admitted, the concerned complainant can be bound by the content of entire document. For this, we may rely on section 121 and section 15 of Bharatiya Sakshya Adhiniyam. And in addition to this, the concerned complainant is bound to prove. We have to remember and keep in our mind that signature of cheque inter alia sufficient to draw presumption of section 139 of NIA. But to rebut the same, you are not supposed to put up your defense beyond reasonable doubt. You may do so by submitting a probabilizing defense so that you may create the possibility in the case and could raise a suspicion and could claim the acquittal. So everything is mathematical. We have to emphasize on the law point, the point in support of our defense to have the proper probabilizing defense and to be succeeded in such false cases. I think I am totally able to cause all of you to understand the important topic. See you in the next video. Till then, Jai Hind, Jai Bharat.